Good morning. My name is Employment Judge Mackay, and we're here today to deal with a discrimination and unfair dismissal case, amongst other things. I'll be your judge for this hearing today. Although it is a discrimination case, as I mentioned, I understand the parties have agreed to me sitting alone as a judge without wing members. I'm getting nods, so that's good. Can I just ask who we have today representing the claimant?
Mr. Crozier of counsel for Mr. Farmer.
And for the respondent?
Mr. Darajiwala, madam.
I'd like to start with a few housekeeping matters, if I may. There will be no recording by any one of these proceedings today, and to do so would be contempt of court. So I want to be absolutely clear about that from the off. So if anyone started recording, I hope you haven't turned it off. The second thing is, as would be the case in a normal court hearing, all mobile phones must be switched off. Can I just briefly deal with the documents that we have before you? Everybody, I hope, who's representing today or as a witness has a 109-page bundle, because that's the one I've got. Is that right?
Yes, madam.
Yes.
Yes. Now, of course, because this is a remote hearing, it works slightly differently from a normal case in that I can't necessarily see what the witnesses have in front of them, and the same for counsel. But I want to ask, in relation to the witnesses who are present, whether they have bundles that are completely clean with no additional notes to assist them.
Yes.
Yes.
I've noticed in the room that we only have 3 witnesses, including the claimant themselves. Is there a witness missing?
Yes, madam. Jasmine Good of the respondent's witnesses has been unable to connect via CVP. She's currently in Borneo on a conservation mission of some description, and the respondent only received information of this very recently.
When?
2 days ago, madam.
Mr. Crozier, were you aware of her non-attendance?
No, madam. First, I've heard of it, and I must say I'm very disappointed. As you will have seen from the papers, there is a real issue about what was said by Ms. Good to my client, and her attendance and cross-examination was very important.
Are you happy for me to admit it, but attach what weight is appropriate?
I'll come back to weight in closing submissions, but I don't object to you having read it and it being admitted in evidence.
All right. Well, in relation to the 3 witnesses we do have, when you give evidence, I will want you to confirm that there's no one else in the room with you. How do we propose to deal with oaths or affirmations via this video link? I'll ask counsel that question.
For Mr. Farmer, I've discussed with Mr. Farmer. He intends to affirm, so there's no issue about him having access to a holy book. And madam, I'd be content for either you or indeed I could take him through the affirmation as necessary.
Yes, if you deal with the affirmation. And for the respondents' witnesses?
Madam, exactly the same. I've spoken with both of my witnesses and they both wish to affirm as well. And if you are content, I can take them through the affirmation as well.
That's perfectly fine. Can I go on to next to what I've read? I've read the pleadings, obviously. I've read, in terms of the policies and procedures, only the disciplinary procedure for now. I've skim-read the witness statements, and I want you to assume that I have read them and go straight into cross-examination of your witnesses. I've also read the list of issues, and I have a couple of questions about those. They are agreed, is that correct?
Yes, madam.
Correct, yes, and you may, madam, have picked up on the typo in paragraph 12.
Yes, insofar as conduct is made out, that is the harassment we're talking about here. Did it relate to the claimant's protected characteristic of disability? That should say gender.
Correct.
Yes, madam.
So the list of issues deals with unfair dismissal, contributory fault, direct sex discrimination under section 13 of the Equality Act, harassment under section 26(1 of the Equality Act based on gender. And there is an issue about time in relation to both of those, as I understand it. Is that correct? And wrongful dismissal is a separate claim arising from the failure to provide the claimant with notice. There is a Polkey point taken, and just to explain to those who don't know what Polkey relates to, it's said in the list of issues that if the claimant's dismissal was procedurally unfair, would the claimant have been dismissed in any event? Is that a point still taken? Is that still a live issue within this case, the Polkey point? As for both of you, I think. My question.
I do understand it to be a live point, Madam, yes.
Okay. All right. Do we have agreement as to who is starting today, given that this is dismissal and discrimination as a case?
Yes, I think we do, and I think it is agreed that the claimant give evidence first.
Fine. I just have one further question, and it's a question really for both of you. I note in the list of issues, obviously we go through the various steps that we need to go through in order to determine unfair dismissal. But I noticed in the disciplinary procedure of the company at page 45 in the bundle that there is a clause 3.1 that says there must be written notice of the disciplinary procedure, a disciplinary meeting rather, given to the employee before they're asked to attend. Am I right in thinking there was no such notice in this case?
Yes, Madam, that is correct.
Do you regard that as a breach of contract, Mr. Crozier? Is that how you're putting it?
It goes to the wrongful dismissal question.
Wrongful dismissal.
As well as to unfairness, of course.
Oh, yes, indeed. Indeed. And your witnesses will deal with, the respondents' witnesses will deal with the lack of provision of notice and the reasons for that?
Yes, Madam, it should be dealt with comprehensively.
It's a little surprising to see that in this day and age, I must say, but I say no more than that at this stage. All right, is there anything else before we start?
Not from the claimant's side, no.
No, nothing from the respondent, Madam.
So which evidence are we hearing first?
I call Mr. Farmer. And Mr. Farmer, can I check that you can see and hear me?
Yes, I can.
The judge has asked me to take you through the affirmation. I understand that's the way you want to confirm your evidence. Could I ask you, please, to repeat after me? I do solemnly, sincerely and truly.
I do solemnly, sincerely and truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth, the whole truth and nothing but the truth.
Shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Farmer. Now, in the bundle of documents in front of you, could I ask you please to turn to page 77, where you should hopefully have a copy of your witness statement?
Yes, I've got that.
Could I ask you, first of all, Mr. Farmer, to confirm your full name?
Yes, Francis Farmer.
And the address given in your witness statement of 21 Standon Way, is that still your address?
Yes, it is.
Have you read your statement recently?
Yes, I have.
Could I ask you please to turn to the final page, which should be page 87?
Yes.
The version I have runs to 36 paragraphs and then a statement of truth. Is that the same on the version you have?
Yes, it is.
Could I ask you please to just read out the statement of truth?
Certainly. I believe that the facts stated in this witness statement are true. I understand that proceedings for contempt of court may be brought against anyone who makes or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth.
Madam, I understand the version the tribunal has is unsigned. Are you content that Mr. Farmer has confirmed the truth of his statement on affirmation? I'm
content with that.
Very well. Mr. Farmer, if you wait there, there will be some further questions for you.
Before that, Mr. Farmer, as I alluded to earlier, can you please confirm that there's no one else in the room with you and you have no additional notes with you when you're giving evidence today? And also please confirm that you have a clean copy of the bundle.
Yes, there is no one with me, ma'am, and I have no additional notes, and I also have a clean copy of the bundle, ma'am.
Thank you.
Thank you. Good morning, Mr. Farmer.
Good morning.
Now, Mr. Farmer, if I'm looking over here at any point in this cross-examination, it's because that's where my bundle is. I mean no discourtesy by doing that. Now, I have some questions for you, and the first one is, you began at EEF as a store assistant in June 2010.
Yes, that's right.
And you were eventually promoted to being a supervisor in 2016.
Yes, yes.
So a supervisor is a more responsible role, isn't it?
Yes, it is. Yes.
Held to a higher standard than a store assistant.
Absolutely, yes.
You then therefore better understand in that role how you're expected to conduct yourself as an employee.
Yes.
Now, having worked for EF for around 10 years, you were also aware of the kind of store that it was.
Yes, health food store, isn't it?
Broadly speaking, what its values were.
Well, yeah, like I said, it's a health food store.
What its ethical commitments were.
No, I mean, it's a health food store, so, you know, that's what
Then
it's
you
about.
must have understood that the kinds of ethical commitments that EEF had were integral to the kind of store that it was.
No, I don't get you.
See, you must have understood, for example, that ethical commitments that EEF made were integral to how it represents itself to the public.
Oh, well, no, I didn't really. You know, it's you know, when I joined, it's about 10 years ago, you know, it was just a small scale health food shop, you know, supplements and stuff like that.
Okay,
I don't
well,
know what this ethical business is you're talking about.
well, let's look at that. Can we go to page 38 in the bundle, please? Do you have the bundle in front of you?
Yes, yes.
Great. Please, could you go to page 38?
Yeah, I've got that.
Great. Now, this is a statement, or it's part of a statement of EEF's core principles, isn't it?
Well, maybe. I mean, it's not the sort of thing I'm used to seeing, I'll be honest with you.
And the bit I've taken you to is specifically about the seriousness of climate change, isn't it?
Well, yeah, as in this document, but, you know, I mean, you know, I don't happen to believe in any of that stuff. So, I mean, I don't really know what you're getting at.
Well, staying with that document doesn't suggest that climate change is a hoax, does it?
Well, I guess not, but it's just more liberal propaganda, isn't it?
Well, that aside, it's something you can see from the language of that statement that it's something that EEF takes very seriously, isn't it?
Well, I think there's a difference really between, you know, people like me who, you know, go into the you know, the shops, work hard for EEF, and what, you know, the founder, you know, is off doing with all her business and what she believes in. I mean,
That's
no.
not the question I asked you, Mr. Farmer. The question is, from the language in that statement,
Yeah.
these are principles that EF clearly takes seriously, aren't they?
No, this is all news to me. This is the, you know, the language of evil in earth, if it's anybody. This is the language of, you know, sort of liberal propaganda you can get in the Guardian. I mean, I don't know. That's not the rest of us.
Well, Mr. Farmer, I'm going to put this to you. Having been at EEF for as long as you have,
Yeah.
you must have known that these values were an important part of the identity of the store.
No, it's all news to me.
You must have known that they were an important part of the principles of the people who shopped at EEF.
No, I mean, the people who shop at EEF, you know, they you know, they like to buy quality, you know, food and stuff like that. But yeah, they don't come in talking about stuff like this. I have a, you know, good relationship with many of the customers. They don't come in talking to me about ecosystems and species and this and that and the other.
Thank you, Mr. Farmer. Well, we'll come back to this, but I want to move on to a different point now. Would you say you have a good sense of humour?
Yeah, absolutely.
In fact, you have a reputation for having a good sense of humour, don't you?
Well, I like a laugh. Who didn't?
You have a nickname, in fact, don't you, in store, Fran the Man?
Yeah.
Now, that's a nickname that makes direct reference to your sex, isn't it?
Well, yeah, but I mean, it's, you know, because basically I'm the man. I'm the only man there. You know.
Well, so it doesn't sound like you find it objectionable, does it?
What? I don't find it anything to be, you know, ashamed of.
Since you never raised any complaints about this nickname.
Well, why would I? No, I haven't raised any complaints about it. You know, it's a sign of how important people see me, and you know, I am the supervisor there. I am the man.
Well, at EEF, the work atmosphere was laid back, wasn't it?
Yeah. You know, we like to laugh.
Okay, so you'd engage with banter with the other employees whilst you worked.
Yeah.
Have a joke.
Yeah, we all do. It's it's a nice place to work. Until I got sacked, it's a nice place to work.
So it was a light-hearted place to work, a nice place to work.
Yeah, like I said, until things sort of changed. Towards the end of last year.
Right. Now, you've made allegations about man flu in these proceedings, but you've never raised these at any time, did you, formally?
Yeah, but I think what you have to understand is, Jasmine Good and Pamela Wilson, they had it in for me.
Well,
and this all started, with the stuff about man flu. I was off sick. I was ill, and I couldn't come into work. A number of times at the end of 2019. That's different. It all changed it.
well, the fact is, Mr. Farmer, the first time you ever formally raised concerns about these man flu comments was in your disciplinary hearing on the 15th of March 2020. Isn't that right?
Yeah, but that's because you should understand what was going on there. They were out to get me.
And you only did so
I
at the
had
conclusion.
and it is proven by the fact that I was sacked.
But you only raised this at the conclusion of that meeting as well, didn't you?
Well, that's because I was completely surprised by what was going on. I was bounced into that meeting. How would you feel?
So no formal complaints.
I mean, you've heard from the judge. It's surprising, isn't it? They don't. They just told me come to a meeting. Next thing I know, it's a disciplinary. How would you feel?
Well, I'm not here to answer questions, Mr. Farmer, but you never raised any formal complaints prior to this point, did you?
No. I admit I didn't. But you should. They were out to get me.
Very well. Now, Mr. Farmer, I put to you that you took absolutely no exception to these references of man flu that were made during the course of your employment, did you?
Yeah, but that's because, like I said, they're out to get me. This all was going on and on and on. At the end of November, beginning of December, telling you.
And you've produced no evidence to demonstrate this, have you?
Yeah, but I recorded it.
Well, Mr. Farmer,
I recorded Jasmine Good saying it to me, because it happened a number of times. And one time when I thought, I'm just gonna, I used to watch the Rockford Files, and I thought I'm gonna do a Jim Rockford. So I got my phone, and I recorded it. I've got that recording.
Mr. Farmer, hold on a moment. Were counsel aware of this at all, that this recording had taken place?
Madam, I must say it's news to me, but Mr. Farmer says he has it.
I do. Yeah.
And it may well be the case that can be played quite shortly to this tribunal. It's clearly relevant to an issue between the parties, and it may well completely resolve that issue. So much as it's taken me by surprise, we have that evidence there, and I'd invite you to admit it.
Well, firstly, the relevance of it is only one part of the balancing act that I have to consider, and the factors I have to take into account. Why was it not disclosed? That would be my first question. What is the answer to that?
Madam, I have no answer because I did not know that it existed. I do not know.
I'm going to ask Mr. Farmer that question. Mr. Farmer, why didn't you disclose it?
Well, because it's like my ace in the hole. I thought I'd keep that. It's my my evidence. Like I said, I used to watch the Rockford Files. I've seen how it works. I know how processes like this work. I just needed that evidence just in case. I've got a strong case, but hey, it's something like that. You've just got to keep back, haven't you? You don't just release that. That's your best piece of evidence.
Do I take it from what you've said that you did understand that you had a duty to disclose relevant information, whether it helped you or it didn't?
Not really, no. I mean, that's not the same, is it? I think my solicitor said something to me about, there's documents this, documents that. I didn't really have anything, did I? I mean, they've got all the documents.
Mr. Dorjiwala, what is your view?
Well, Madam, I have no idea what it says. It absolutely should have been disclosed if it is what Mr. Farmer purports it to be at a much earlier stage, and it's now hugely prejudicial for me to be effectively ambushed by this evidence this morning.
Mr. Farmer, your position is that this is a recording that makes it clear that the word man flu was used on at least one occasion. Is it one recording of one incident?
Yeah. Yes, it is. Yeah.
Well, I hesitate to allow it in, but I'm going to. So I'm going to allow for a break. Ordinarily, that would be for about the length of time needed for council to listen together to this recording. Let's assume for the purposes of this that that's been done. And let's assume for the purpose of this that we've heard it. Do you want to carry on, Mr. Dorjiwala?
Yes, madam, I'm very grateful. Thank you. Mr. Farmer, well, thank you for that recording. That was just one incident, wasn't it?
Yes.
Okay.
Yeah, that's recorded, but you know, this is all a pattern. That's why I needed to record it, didn't I?
And all we heard was the words used. We heard no objection from you, did we?
Yeah, but you know, I was doing my thing, wasn't I? I was doing my thing. I needed to, you know, get that recorded. You're not going to just go, yeah, aha, I got you. You know, I've got Jasmine good because that's what she always used to say to me. Mansplaining, that's what she said.
So
And
to clarify,
I've got that time. I've got it that time.
So to clarify, you did your thing, and your thing being not objecting to the use of that language.
No, no. My thing was I needed to record Jasmine Good, you know, saying mansplaining to me. No, that's not about not objecting. That's no.
Well, Mr. Farmer, in light of the lack of any formal complaints prior to the 15th of March, I put to you that you took no exception to any of the references to Manfully that were made during your employment, did you?
Well, you know, it's like this. If there you are, right, you know, and there's all this stuff going on, and you know you're ill, they don't believe you. You come in, you know, time after time, and they're taking the mickey out of you. You got to do something, and you know you got to. I was having to see, you know, one day I knew I was going to have to do something. As it is, look what happened. As it is, they sacked me.
Well, Mr. Farmer, getting back to the point, you knew that those comments were made in good humour, didn't you?
Well, I wasn't laughing.
That's why you raised no formal complaints.
Well, you know, like I said, I had to tread carefully. You know, this is Rockford Files territory. I told you.
Well, unfortunately, Mr. Farmer, I'm not entirely sure what the Rockford Files are, but we'll move on. Can I take you to page 44 of the bundle?
Yes, I've got that. Yeah.
Now, Mr. Farmer, that's EEF social media policy, isn't it? As it's titled.
Yes.
And as a supervisor, presumably you must have known about this.
No, this is the sort of thing that, you know, is just being put to me, you know, I think at the time of the disciplinary.
But you agree that as a supervisor, it's the kind of policy that you ought to have complied with.
Yeah, yeah. So you could say that about anything. I mean, you know, as a supervisor, you're supposed to know this, that, and the other. I mean,
Right.
yeah, I guess.
Well, staying on that page, you can see subparagraph F, I hope, in the bundle.
Yeah.
That requires employees to apply the same standards of conduct online as they would offline, yes?
Yes.
Okay.
But look, you know, on the next page is paragraph L. Employees have the right to freedom of thought, opinion, and expression, and can use social media as a means of communicating these.
Well, yes, Mr. Farmer.
You know, I've got my rights. I've got my rights. And they know it. It's in this document.
Well, let's look above that, shall we, for a moment? And that
All
states that inappropriate content could be that which reasonably offends a third party.
What does that mean? That sounds like legal speak to me. I don't know what that means.
Moving on down to M.
Yeah.
That effectively states that you must remain appropriate and polite when disagreeing with other people's opinions.
Well, I do.
And going down even further to V.
Yeah.
It's on the page after, and if you could just read that to yourself quickly.
V.
V, yes.
Well, was that on the other page?
Sorry, it's on page 46, yes.
Yeah, okay.
Essence of that is that derogatory or offensive conduct or conduct that could bring the company to disrepute could engage the disciplinary procedure. Is that correct?
Well, that's what it says. But, you know, I mean, what's that got to do with anything?
Well, I want you to keep all this in mind when we go to page 52 of the bundle.
Yeah.
Mr. Devereux, would you mind, for the observers present who haven't seen this tweet, would you read it out so that they understand what the offensive or allegedly offensive material is that formed the basis of the dismissal?
Yes, madam. So, Mr. Farmer, what I've taken you to is, and I'm sure you'll accept, is your Twitter profile, a public Twitter profile, yes?
It is, yes.
It says that you're based in Bristol,
Yes.
and you clearly identify that you work for EEF in Bristol.
Yes.
Now, there's a tweet which I'm going to read out for the benefit of the observers, and it's on the page, but I'll read it out. Global warming ? What a load of nonsense ! It's a complete scam, and anyone who believes in this crap is an absolute moron. You wrote that tweet, didn't you, Mr. Farmer?
Yes, I did. I stand by it.
Okay, well, I want to focus on the first half of this tweet. That's effectively denial of global warming, isn't it?
Yes.
Calling it a scam.
Because it is. It is
Crap.
a scam. Yeah. I mean, you got to speak up about these kind of things.
Now, this is plainly a view that's in conflict with the climate change values that the company has.
Well, they may do now. It seems like it's completely, disagreeing with Evelyn Earthy.
Climate change values that I've taken you to this morning.
Yeah, very conveniently, these climate change values seem to be, but look at that. They've got these climate change values.
Well, Mr. Farmer, you must have known when you were sending that tweet that they would have been incompatible, that it would have been incompatible with the core values of the company that you were working for.
No, because this stuff, these values are kind of news to me. Like I said, I've been there a long time. I don't know, suddenly there's Evelyn Earthy's gone off on one.
Well,
ask her about that kind of thing. I mean, I don't know why you're asking me. All I'm doing here is I'm pointing out what's the truth.
Well, let's move on to the second half of that tweet, shall we? You refer to global warming as crap, and you refer to the people who believe in it as, I quote, absolute morons.
Yeah.
Now, notwithstanding your own views, that's not a pleasant thing to call someone, is it?
Yeah, well, the truth hurts, doesn't it?
So it's reasonable to assume that people wouldn't react well to being called morons.
Well, they probably wouldn't, but they are. They're sheeple, and they just follow, what's said in liberal media.
It's reasonable to say that they would also be offended by being called morons.
Well, like I said, the truth hurts.
Especially the case if they had a deeply held belief in the truth of climate change.
Well, you've got to shake people up. You've got to shake people up. You've got to get that message out there.
Well,
it's a sham.
Let's look at the screenshot that's next to the tweet, and again, for the benefit of the observers, I will read it out. We can see two replies to your tweet, can't we?
Yes.
The first is from Simon Green. I'm just going to read it out. It says, "This is totally unacceptable, especially from an employee who works at Ethical Earth Foods. Very disappointing to read." Now, he expresses a deep unhappiness with what you've expressed in your tweet, doesn't he?
Yeah.
He expresses his offence at what you've said.
Yeah.
He also tags EEF in his EEF's profile in his response, doesn't he?
Yeah.
So he's clearly aware you work. Well, he's clearly aware you work for them, doesn't he?
Yeah, I mean, you can tell that anyway because I've said it myself.
And how many times was his reply to you retweeted?
What is that? 17? Something like that? I don't know.
Well, the retweet is the one next to it, Mr. Farmer. So that's 8 times.
Yeah. 17 likes, isn't it? Yeah.
And 17 likes.
Yeah.
Now,
that's a sign. That is, that's a sign that I'm getting people's attention.
Well, okay, let's move on to the second reply. And again, I'm going to read it out. This is from someone called Femi Stevens. And he says the following in reply to your tweet. "This is so irresponsible. I thought climate change mattered to Ethical Earth Foods. Boycotting." Now, he identifies that climate change is a value that, and I quote, mattered to EEF. So he's aware that it's a core value.
God, who's he? I mean, I don't know. He's probably a friend of Evelyn Earthy's. I don't know what these people get up to. I mean, they're busy off doing their thing and going on about #MeToo and all this, all very woke. What doesn't mean anything.
He also identifies that you work for EF, doesn't he?
Yeah, well, that's because I put it down there. It's on my, my profile. That's what I do for a living.
And
I don't know what you
crucially,
do for a living, but I'm there. I go into that shop every day. I work hard for Evelyn Earthy, and that what I've got is I've got sacked.
well, Mr. Farmer, it's my great
That's the important thing here that you're getting away from.
Well, Mr. Farmer, it's my great pleasure to do this job as my living. But my next question is this: he crucially says, Mr. Stevens says, that he was boycotting EEF, doesn't he?
Yeah, well, like I said, the truth hurts.
And how many times was that reply to your tweet retweeted?
Well, look at that, 109.
109 times. And how many times was it liked?
393.
It's quite a lot of likes and retweets, isn't it?
Well, that's because, again, it's getting through. The message is getting through there. It's getting through, Now, by virtue of the numbers of retweets and likes on the replies to your tweet, would you agree, therefore, that by virtue of all of this, a vast number of people have seen not only your tweet, but the replies? Well, yeah, great.
Well, Mr. Farmer, I therefore put to you that your tweet was in fact inappropriate and it was in fact offensive to third parties.
Well, you say that, and these people may say that, but what about all those people out there, the silent majority? The people like me who kind of say, look, we've had enough. We've had enough. We like to drive our cars. We want to see, our economies flourish, and all the rest of it. But we don't, it's just, we're just being silenced. We're being silenced. I mean, we don't see, where's that? Where's that evidence?
Well, Mr. Farmer, I also put to you that you were not polite in the manner in which you expressed your opinion here.
There isn't time. There isn't time. Well, that's what they say anyway, isn't it? They say there isn't time, and they're taking over. And so I've got to get hard on this and say this is the truth.
Crucially, Mr. Farmer, your views on climate change were in conflict with EF's core values and did, in fact, bring the company into serious disrepute, didn't they?
Well, I think they're in conflict with what Evelyn Earthy believes in, but
so therefore,
in my store, they they know me and they know that I do a good job and I'm the man, and I don't see anybody saying to me when I talk about these issues, you're in conflict with what we believe in or anything. They're there and they. No one says anything. They kind of, they go along with me. I'm sure, that's because people hold me in respect.
Well, Mr. Farmer, I'm just going to put this last point to you. I therefore put to you that this conduct that we've been through in relation to this tweet was properly characterised as gross misconduct, was it not?
Well, they say that. They say that.
Thank you, Mr. Farmer.
I wouldn't, because that's me. I'm a hero. I am. I'm putting it out there, and that's because that's the truth. You can't sack someone for speaking the truth. That's clearly unfair.
Thank you, Mr. Farmer. Madam, I'm conscious of the time. I do have further matters, but I can address them in submissions. And Mr. Farmer, in that case, I have no further questions for you.
Thank you. I've got one question before there's any re-examination, Mr. Crozier. Mr. Farmer, have you expressed similar views to that which we have heard about in the tweet in the workplace in the last 10 years?
Yeah, people know me. I talk, I talk the truth. I don't, I'm not backward in coming forwards in my beliefs.
So have you verbally expressed them clearly to other people within the organisation in the past?
Yeah, yeah. I mean, I talk about this stuff all the time.
Has anyone ever objected?
No. Why would they? If they are a good bloke, I mean, they're not going to object.
Thank you, Mr. Crozier. Any questions from you?
Thank you, Madam. One question from me. Mr. Farmer, you were asked about whether you had formally raised the man flu comments made by Ms. Good, and you accepted that you hadn't formally raised them. Could I ask you please to turn to page 83 of the bundle and look at the first sentence of paragraph 19 of your witness statement?
Yeah. Oh, yeah, that's true. Yeah. because I did say, I said something to Pamela Wilson, and yeah, you know, she didn't want to know. That's because that's all part of what I've been talking about today. You know, it's all, they were just not going to listen. They were just closing me down. They were looking for a way to get rid of me.
Thank you, Mr. Farmer. That was the only issue I wished to raise. And that, Madam, closes the claimant's case.
Thank you, Mr. Crozier, for that. So is there anything else before we start with the respondent's evidence?
No, Madam, I don't believe so.
Nothing further from me, Madam.
So, Mrs. Dorojualo, who are we calling first?
Madam, I call Pamela Wilson.
Morning.
Good morning. Good morning, Ms. Wilson. Can you hear me?
Yes, I can hear and see you. Can you hear and see me?
I can hear you, and I imagine I'll be able to see you in a moment. I imagine it's just the technology. Ms. Wilson, I'm going to first ask you to speak an affirmation, as this swear you in. And as was discussed earlier, I understand that you wish to affirm.
Yes, I do.
Thank you. Could you please repeat after me? I do solemnly, sincerely, and truly declare.
I do solemnly, sincerely, and truly declare.
And affirm.
And affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you. Now, Ms. Wilson, you should have a bundle in front of you. Can I ask you to turn to page 88 of that bundle, please?
Yes, I have that in front of me.
That should be the start of your witness statement.
Yes, it is.
Now, could you confirm your name and address?
Yes, it's Pamela Wilson, and the address is Ethical Earth Foods Limited, Unit 3, Commercial Yard, Bristol, Avon, BS3 1PQ.
Thank you. Now, could you turn to page 97 of the bundle, please?
Yes, I have that in front of me.
And that's the end of your witness statement. The one I have, it runs to paragraph 41 with a statement of truth at the end running. There's an internal pagination of page 10 at the bottom.
Yes, that's correct.
Now, Ms. Wilson, have you recently read your witness statement?
I have, yes.
Is it accurate?
Yes, it is.
Do you wish to add anything?
Not at the moment, no.
Madam, my witness statement is unsigned, but I propose to take the same approach as my learned friend and ask the witness to read out the statement of truth, if that would be appropriate.
Yes.
Ms. Wilson, please could you read out the statement of truth which begins, I believe?
I believe that the facts stated in this witness statement are true.
Thank you, Ms. Wilson. There's nothing further from me, but I'm sure my learned friend will have some questions for you.
Before we get to that, Ms. Wilson, in the same way as I did with the claimant before he gave evidence, can you confirm there's no one else in the room, that your bundle is clean and you have no notes to assist you?
Yes, I can confirm all that.
Thank you.
Ms. Wilson, can I check, first of all, you can see and hear me?
Yes, I can.
Good morning to you. I want to begin, please, by just running through a bit of the chronology to your employment with EEF. You replaced Colin Sylvester as store manager in August of 2017.
Yes, that's correct.
So since then, you have been in charge of the store and in charge of recruitment to the store?
Yes.
And since you took over from Mr. Sylvester, it's right, isn't it, that no men have been recruited to work in the store? Is that right?
I can't remember exact dates, but we definitely have had men working here in the past.
In the past, yes, but since you took over as store manager with responsibility for recruitment into that store, there have been no male recruits.
I suppose that's correct.
And by the time of the claimant, Mr. Farmer's dismissal in March 2020, he was the last male employee. Is that right?
Yes, he was.
Okay. I'd like to please take you to the disciplinary and capability process operated by EEF That begins at page 39. Could I ask you to turn that up, please?
Yes, I've got that in front of me.
And the part I want to take you to is at page 41.
Mm-hmm.
I'm just going to take you through a few parts of the procedure, and I'm going to read them out for the benefit of any observers. First of all, paragraph 1.1. This procedure is intended to help maintain standards of conduct and performance and to ensure fairness and consistency when dealing with allegations of misconduct or poor performance. It's right, isn't it, that the process is in place to be followed to ensure fairness both to those who are subject to the policy and to EEF?
Yes, that's my understanding, yes.
And I want to please come down to paragraph 3.1 at the bottom. Do you see that?
Yes, I see that.
Requirements that you give written notice of a disciplinary hearing, including sufficient information about the alleged misconduct, including copies of relevant documents and witness statements. Now, it's right, isn't it, that in Mr. Farmer's case, he was given no notice of the hearing, nor any information about that hearing or documents before he got into the hearing itself?
Yeah, that's correct, but it was incredibly urgent. I felt I had to speak to him immediately, so I didn't really have the chance to give him notice because I wanted to deal with it straight away.
Well, Ms. Wilson, it may well have been the case that you wanted to speak to him urgently, but what you did is launch into a disciplinary hearing and dismissed him. That wasn't urgent, was it?
I felt that it was, based on what happened with the tweet and what happened in the meeting.
I want to come on, please, to paragraph 3.2, the right to be accompanied to a disciplinary hearing. Mr. Farmer wasn't notified of his right to be accompanied to the meeting and indeed wasn't accompanied. That's right, isn't it?
Yes, yeah, that's fine. That's correct, I suppose.
And over the page, please, 3.3. You should let us know, you being the person subject to the policy, so in this case, Mr. Farmer, should let us know as early as possible if there are any relevant witnesses you would like to attend the hearing or any documents or other evidence you wish to be considered. Mr. Farmer had no opportunity to call any relevant evidence or witnesses to the disciplinary hearing, correct?
No, I suppose he didn't.
Now, I want to pick up on the timings of all of this.
Mm-hmm.
The store opens at 9 o'clock. You
Yes.
had your habitual coffee down the road with Jasmine Good sometime perhaps shortly before the store opened. Do you remember what time that was?
Perhaps about 9 a.m. just before.
Okay. So assuming Ms. Good makes you aware of the tweet at about 9 o'clock, at 9:15, you drag Mr. Farmer off the shop floor. At 9:30, he is in a disciplinary hearing, which runs to 10:15. And by about 10:30, you've made the decision to dismiss. It took you, on that timing, about an hour and a half from first learning of the alleged misconduct to having reached a decision to dismiss an employee of 10 years standing. Have I understood that chronology correctly?
Yes, I suppose you have.
You were in a rush, weren't you?
I was I wanted to deal with the matter urgently because I felt that the tweet needed to be addressed quickly, but I wouldn't say that I particularly wanted to dismiss him or going into it or was in a rush to do that. It's just what happened in the meeting and what I felt was necessary based on what happened.
Well, let's deal with that point about urgency because you keep raising it. You could have followed the following course, couldn't you? At 9 o'clock, learn of the tweet. At 9:15, drag Mr. Farmer off the shop floor into a meeting room. At 9:30, explain to Mr. Farmer that his tweet is considered by you to be personally offensive and could he remove it, please? And tell him that you will conduct a disciplinary hearing sometime later in the week, having given him proper notice and a proper opportunity to call evidence. That would have dealt with the urgency, wouldn't it?
I mean, I suppose it might have done, but the fact is that when I did deal with it urgently and I did ask him to delete the tweet, he refused to, and I felt that it needed to be addressed quickly and that he needed to be gone so that he couldn't cause any more damage to our reputation.
You refer to having asked him to take the tweet down. It's accepted and agreed that you asked him to take it down and he said no. Can I just reflect here on the requirement for fairness and due notice? You didn't, when asking him to take it down, draw his attention to the part of the social media policy which says that you may require him to take it down, did you?
I suppose I didn't know, but I'd been directing him to different parts of it, so I guess I assumed that he would have known that.
Nor did you give him the instruction that you're entitled to do under the social media policy, that EEF requires you to remove the tweet. Instead, you simply ask him whether he would be willing to delete it.
Yes, I believe that was my phrasing. That's what I asked.
And you didn't explain to him at any point that if he didn't remove the tweet, that would, in your mind, aggravate the situation, did you?
I mean, I thought that would have been a common sense conclusion on his part, given that I'd explained how much damage the tweet had already done.
You see, Mr. Farmer says in his witness statement that had he been given proper time to consider the consequences of his refusal to take it down, he might have acted differently. You didn't give him the opportunity to properly consider his response to that, did you? I
mean, I suppose not, but what I could tell from what I could tell in the meeting, it seemed that he completely stood by what he'd said, and wholeheartedly believed it and wanted to keep it up.
Now, I want to look in a little detail at the relationship between you and Mr. Farmer. Mm-hmm. You tell us yourself in your witness statement that you found him to be unprofessional. You'd find him talking to customers about football and rugby on the shop floor.
Yeah, that's happened a few times.
Bit too blokey for you. Is that fair?
I mean, I suppose.
Yeah. And you also tell us in the dismissal letter that you found his tweet personally incredibly offensive. Yeah?
Yeah, I guess. Yeah, I did.
There was an animosity from you towards Mr. Farmer. He was too blokey and didn't hold the same values as you held. Would you accept that?
Yeah, we had somewhat of a difficult relationship.
I want to ask you, please, about man flu.
Yes. This
was brought up in the second part of the disciplinary hearing when you were announcing your decision. Wasn't the first you'd heard of it, was it?
I mean, I had a memory of it possibly being said on the shop floor.
Let me tell you what was said to you on the shop floor. Mr. Farmer came to you and told you that Miss Good was repeatedly taunting him by telling him that he'd been off with man flu, and you were dismissive rather than engaged with his concerns, weren't you?
I mean, I can't recall whether I was dismissive or not, but come on, it's just a comment saying man flu. It's just a bit of fun. It's banter.
Yeah. It implies, just to focus on meaning for a moment, that men tend to exaggerate low-level illness.
I mean, I suppose it does, but it's just a joke. We all know they do.
Well, it's sexist, isn't it?
I mean, I don't think it's that serious.
I didn't ask you whether it was serious. I asked you whether it was sexist.
I don't think it is, no.
Would it be acceptable for a male employee to say to a female employee, "You're grumpy because it's that time of the month"?
Probably not.
No, it wouldn't, would it?
No.
Now, when this was raised with you on the shop floor, and later when it was raised with you in the course of the disciplinary, you saw no need to investigate it further or take any action in respect of Miss Good's comments to my client, did you?
No, I didn't feel that was necessary. I didn't think it was that serious.
Just a couple more points I want to cover off with you, Miss Wilson. Mansplaining. Now, I think you accept having said to Mr. Farmer to stop mansplaining in the disciplinary hearing.
Mm-hmm. I do.
And it's fair to say, isn't it, that that's not a comment you would ever have made to a woman?
No.
It has gendered and sexist connotations, doesn't it?
I mean, I accept that it's gendered, but I don't think it's sexist.
You said it to belittle my client and belittle his views.
No, I said it because I felt that he was belittling me. He was ranting on and on about climate change and acting like I don't know anything about it. And he was going on. And I just felt very patronized. I felt he was being really condescending. So that's why I said it.
With respect, you didn't accuse him of being condescending or patronizing. You accused him of mansplaining.
Yes, I suppose I did. But I mean, that's my understanding of what the term means.
I want to come on to the comment made by you in the disciplinary that my client needed to man up. Convenient, isn't it, that that seems to be the only part of the recording of the interview that was inaudible? Do you have any explanation for that?
No, I know that I said grow up. I can't speak to why it's inaudible. There's no particular reason why it is.
It wouldn't, though, be uncommon for you to use gendered language in talking to Mr. Farmer, would it? You did it in the very same meeting.
I mean, I wouldn't say it was a habit. I'd done it once before in that meeting.
And your colleagues had also done it to Mr. Farmer.
I mean, maybe Jazz said he had man flu, but I don't think it's much of a habit or anything.
Ms. Wilson, thank you very much. Those are all the questions that I have for you. If you wait there may be some questions from the judge or indeed Mr. Dojawala.
Ms. Wilson, before any re-examination, I want to ask you, consistent with the question I asked the claimant, about Mr. Farmer's behaviour in the store in the past. Has he questioned climate change before? And if so, in an offensive way?
I mean, I've never heard him overtly say anything about climate change specifically, but I have got the impression in the past that his views don't really align with the ethical values of the store.
But you don't recall him specifically making any offensive remarks about climate change, that it's a nonsense or a scam or anything to that effect?
He may have done, but I don't recall it at this time, no.
Presumably, if he had made remarks like that, you would have recalled it.
I mean, if they were put as strongly as the views were in his tweet, I'm sure I would have remembered it, yes.
Thank you. Any re-examination?
Nothing from me, madam.
All right, thank you very much, Ms. Wilson. Call your next witness, please.
Madam, I call Evelyn Earthy.
Good morning.
Good morning, Ms. Earthy. Ms. Earthy, can you see and hear me?
I can. Can you see and hear me?
Just one moment, I think it's just taking. Yes, I can. Now, Ms. Earthy, I'm just going to ask you to, I understand you also wish to make an affirmation, so I'm just going to take you through that if that's okay. Please could you repeat after me? I do solemnly, sincerely and truly declare.
I do solemnly and sincerely and truly declare.
And affirm.
And affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you. Now, Ms. Earthy, you should have a bundle in front of you. Could I ask you to turn to page 98 of that bundle, please?
Yes, you can. I have it here in front of me.
That should be the start of your witness statement.
It is, yes.
Now, could I ask you to confirm your name and address?
Yes, sure. It's Evelyn Earthy, Ethical Earth Foods Limited, Unit 3, Commercial Yard, Bristol, Avon, BS3 1PQ.
Thank you. Now, if I could ask you to go to page 105 of the bundle.
105. Yeah.
That should be the end of your witness statement, running to 30 paragraphs with a statement of truth at the end.
Correct.
Have you recently read this witness statement?
I have, yes.
Is it accurate?
It is accurate.
And is there anything you wish to add to it?
No, not at the moment.
Thank you. Now, Ms. Earthy, could you just please read out the statement of truth which begins, "I believe"?
I believe that the facts stated in the witness statement are true.
Thank you. No further questions from me, but if you just remain there, I'm sure my learned friend will have some questions, and the learned judge will too.
Again, before that, Ms. Earthy, thank you for attending, but can you please confirm, as consistent with the other witnesses, that there's no one else in the room with you?
I confirm that's true.
Can you confirm that you have no notes to assist you giving evidence?
I have no notes.
And is your bundle clean?
It is, yes.
Okay, thank you. Mr. Crozier.
Thank you, Madam. Ms. Earthy, can I just confirm you can see and hear me?
I can.
Can I just begin by asking you about some of the documentation in the bundle? Now, we have the core values document, we have a disciplinary policy, we have the social media policy and guide. I can't find an equality or equal opportunities policy. I infer from that, and I'd like you to confirm whether this is right or wrong, that EEF does not have an equality or equal opportunities policy.
I think, no, we can't have. I think we did have right at the beginning, but I think we were going to change it and update it, but it's not included, no.
Right at the beginning, do you mean right at the beginning when EEF was first established in, I think, 2009?
Yes.
Yeah. More important for EEF to have statements about its core values and police the social media content of its staff than to have a basic policy setting out its approach to equal opportunities and equality issues. Would you accept that?
No, not more important. Just as important.
Just as important, but one has very detailed policy statements and the other does not.
Correct.
On your role with EEF, you are the founder. Also, as I understand it, the chief executive. You are, just to check, you are an employee of EEF.
Yes.
Yeah. And you tell us in your witness statement that you see EEF, your business, the business you founded, very much as an extension of yourself.
Yes.
It is a business that is to fulfill the same values that you hold.
Absolutely.
And the social media policy, disciplinary policy, core values policy apply to you as an employee as much as they apply to Mr. Farmer, Miss Good and Miss Wilson?
We're all as one team, so yes, they should apply to everybody.
I want to ask you about the way in which the appeal came to be handled by you. And I think you tell us in your witness statement that you had to delay your holiday to your home in the Bahamas in order to be able to hear the appeal. Have I got that right?
You have got that right, yes.
And it's right, isn't it, that your holiday to, well, perhaps holiday is the wrong way of putting it, but your trip to your home in the Bahamas was one of, as I understand it, 5 or 6 long-haul trips to the Bahamas and other long-haul destinations that you take every year?
No, the trip this time actually was to go and meet an agent because we're selling that property. So really it wasn't a holiday, it was more of a business trip.
Okay, on that occasion, but it is right, isn't it? There are 5 or 6 long-haul trips to the Bahamas and other exotic destinations every year on your part.
They have been in the past, but as I say, we're selling that property, so that's something we're not going to be doing going forward.
And in traveling to and from the Bahamas and some of these other exotic destinations, it's right that you would often fly by private jet.
We previously have done, yes. I don't understand the relevance of this question exactly, but as I said, going forward, we're not going to be doing that travelling. We're selling the property and a lifestyle change in that aspect.
A lifestyle change commencing, just to put a date on this, in the first or second quarter of 2020.
Does that matter when we make that decision?
Well, I think it might do. So could you please just answer the question?
Yes.
I want to look or ask you about your Instagram account. Now, as I understand it, your Instagram account is now private.
Indeed.
But at the time that Mr. Farmer was dismissed, it was a public account.
I can't remember. Yes, I changed it private. I like to keep my private life private and the business Instagram separate, so more public.
And again, that change in your treatment of your Instagram account occurs at about the same time. It's first or second quarter of 2020.
Around about then, yes. I can't remember exactly when I decided to change it as private.
Prior to that, on your public Instagram account, as I understand it, in your own name, there were hundreds of photographs of you travelling back and forth to the Bahamas on your private jet.
Madam,
is that right?
Madam, I must object here. I've had no sight of any of this. None of it's in the bundle. I'm not sure what Mr. Crozier is referring to.
Mr. Crozier, are there any pieces of evidence in the bundle? If there are, I've not seen them.
There aren't, Madam, no. And the reason for that, we would have dearly loved to have put in many of Miss Earthy's Instagram photographs. They're not there because at some point, we say after Mr. Farmer's dismissal, her account became private, where previously it had been public. And I think Miss Earthy has confirmed that so far.
Thank you, Mr. Torgiuolo. Are you objecting to the relevance of this evidence, or that you've simply not seen it and therefore haven't had a chance to digest it?
Madam, it's principally the latter, yes.
So you do accept that the way in which Miss Earthy led her life and the fact that she made it public before the end of 2019, let's say, is relevant?
I take the point that the questions would be relevant, yes, Madam.
Okay, thank you, Ms. Crozier. Carry on.
Miss Earthy, I think I had asked you or put to you that your public Instagram in your own name had previously contained hundreds of photographs of you toing and froing from the Bahamas, enjoying exotic holidays and private jets.
I wouldn't say hundreds, toing and froing, and put it as flippantly as that. But yes, in the past, I have enjoyed holidays.
Your own presence on social media until you made it private also undermined Ethical Earth Foods' supposed commitment to climate change, didn't it?
Did it?
Well, I'm putting the question to you.
How?
By seeming to endorse many long-haul gas-guzzling or diesel-guzzling holidays every year, rather than a sustainable and modest and low-carbon lifestyle, I would suggest to you.
And as I've said, changes have been made. We're selling properties. We're starting a couple of projects, climate projects to do with carbon offsetting. The world can't be saved in a day, so it's all about taking steps and making changes as you go along, which is what we are about and is what we are doing. And I'm trying to drive forward as a company, which is why Mr. Farmer's tweet was so inappropriate, because it's not what we're trying to stand for going forward.
I want to pick up on a couple of points in your witness statement, please. Could I ask you please to turn to page 99?
Yes.
Paragraph 6, right at the bottom of page 99, talks about you being shocked by the content of the tweet and it being the exact opposite of your cherished core values.
Right.
Yep. Just to be clear, that is your initial reaction to seeing the tweet when you received the letter of appeal, correct?
Correct.
You had formed a view without waiting to give Mr. Farmer the opportunity to explain at an appeal hearing.
So sorry, I didn't understand that. So I don't understand. I took a view of the tweet.
Yes.
Yes. How can you not? It's quite obvious what he's saying.
Over the page, please. And I want to look at paragraph 10.
Yep.
Again, here you talk about the time when you received and first reviewed the letter of appeal.
Yes.
And you describe Mr. Farmer's case that he was dismissed because he was a man and he was harassed as speculation. Yes?
Right.
Again, you didn't wait to hear what Mr. Farmer had to say at the appeal hearing and take a considered view of his case. You'd already made up your mind that it was pure speculation.
Well, Mr. Farmer was quite happy being the man in the team, in the company. It was often on the shop floor, the Francis Farmer show. He liked to, you know, display that he is this hero, the only man in the team, have a chat with the customers, and always lots of banter, as one would like to call it. He was never uncomfortable with anything, so I just found it quite odd.
You'd made your mind up.
I hadn't made my mind up 100%, but knowing his character, I thought it was questionable.
Ms. Searthy, thank you very much for your time this morning. Those are all the questions that I have. There may be some further questions from your counsel or indeed from the judge.
Ms. Searthy, I just want to ask you about the initial procedure carried out by Miss Wilson.
Mm-hmm.
Do you accept that there was no investigation by Miss Wilson, the allegations against the claimant?
I do. There wasn't an in-depth investigation made.
Do you accept that there was no notice given to him or any particulars given to him of the allegations prior to his attendance at the meeting at which he was dismissed?
I accept that that was done all very quickly, but I think Miss Wilson just thought the severity of the tweet and the impact it could have.
I'd ask you about the reason why you think it happened. Do you accept that no companion was allowed to attend to accompany the claimant or trade union representative?
I accept that wasn't offered as an option.
Do you accept then that the procedure was unfair and unreasonable?
I think the reason behind it was fair, but possibly the way around it, maybe.
So you're accepting that the procedure itself was unfair, is that right?
Not unfair, but probably not dealt with as well as it could have been.
Do you accept, given that you undertook an investigation and you undertook interviews yourself, that you recognised at the time of the appeal that the procedure undertaken by Miss Wilson was unreasonable?
I didn't think, again, I think I was just thinking of the reason behind it and Mr. Farmer's attitude towards everything. So I didn't see it as wholly unreasonable, no.
Thank you. I've nothing further for this witness. Any re-examination?
Madam, yes, just one question. Ms. Earthy, you mentioned carbon offsetting in your responses to Mr. Crozier. What, if at all, do you understand carbon offsetting to be?
It's a reduction in emissions in carbon dioxide or other gases. They can be made in order to compensate for emissions made elsewhere. So we're going to work with other companies, work on certain climate projects to trade that off.
Now, when, if ever, have you engaged in carbon offsetting?
That's something that I'm looking into currently, not me personally, but it would be more of a company, not me personally.
Thank you, Madam. I have no further questions.
Okay, well, we know that Ms. Good is not giving evidence on behalf of the respondent, as we've heard before now. So any further witnesses or evidence from the respondent?
No, Madam.
Right. Let's move on to submissions. I noticed that I haven't received any written submissions, but that's all right. It's a very short hearing, but are you ready to proceed now with oral submissions?
Yes, Madam, I am. Yes.
Okay. Please proceed and do keep them brief.
Madam, I will indeed. Madam, the claimant's claim concerns essentially four matters: an unfair dismissal claim, and related to that, a wrongful dismissal claim, a direct discrimination claim, and a harassment claim. At its core, this claim is quite simply about an incredibly offensive tweet which was sent by the claimant. It's deeply troubling that Mr. Crozier has led as much evidence as he has in the course of his cross-examination, particularly in relation to the Instagram account. And Madam, it's submitted on behalf of the respondent that none of these claims should be successful, and for the following reasons. In relation to the unfair dismissal, it's the respondent's position, as it has been consistently since the claimant's dismissal on the 15th of March 2020, that the reason for the claimant's dismissal was his conduct, namely the posting of an offensive tweet which denied the effects of climate change. It's clear that this tweet violated the core principles of the respondent, and in addition, the tweet was phrased in an offensive manner which was contrary to the respondent's social media policy. The tweet was seen by a significant number of people by virtue of the replies which were widely retweeted, replies which expressed their concern about how the claimant, who had identified himself as an employee of EF Bristol, reflected upon the respondent. The claimant was given the opportunity to delete this tweet, but he did refuse in the course of his disciplinary hearing. To do so would have resulted in his dismissal being reversed. This did significant damage to the respondent's reputation and, in sum, was an act of gross misconduct on the part of the claimant. And this was the sole reason for the claimant's dismissal. And for the avoidance of doubt, it is denied that any factor beyond this tweet was the reason for dismissal. So for this reason, it's submitted that the respondent plainly did have a genuine belief in the claimant's misconduct, and it was wholly within the range of reasonable responses for the respondent to then dismiss the claimant. Turning to the next question of procedural fairness, it's submitted that in all the circumstances, a fair procedure was followed. The respondent carried out a sufficient investigation into the tweet, the source, content, the reach of the tweet was patent on its face. And as such, there was no need for any protracted investigation. In fact, it was necessary to address this matter with a degree of urgency. And indeed, it would have made no difference if a more intensive investigation had in fact taken place simply because of how patent the tweet was. Although it's not admitted that there were any procedural failings, any such failings were remedied by the appeal hearing, and it is notable that the claimant failed to make any allegations of procedural unfairness as part of his appeal. It's submitted that this is because the claimant did not perceive there to be any procedural failings in his disciplinary hearing. It's therefore submitted that in all the circumstances, the dismissal was procedurally unfair, but if the tribunal is not with the respondent on this point, then without prejudice to the preceding submissions, it is nonetheless submitted that, for the reasons already submitted, the claimant would have been dismissed in any event if fair procedure had been followed, and additionally, that his conduct plainly contributed entirely to his dismissal.
Mr. Jarala, can I stop you there? Let's just focus on procedural unfairness for a moment, please.
Yes, madam.
Are you seriously contending as a submission, and I appreciate you put it in the alternatives, that this dismissal was procedurally fair?
Madam, I am putting it in the alternative in the sense that there are perhaps points where there may have been failings, but on the first point, oh, have I gone? Hello? Am I back?
I can hear you. I can hear you. I can see you. So do carry on.
Not manufactured on my part. It's accepted that there were certain problems in the procedure for the disciplinary, but the point I would perhaps reiterate is that no such concerns were raised by Mr. Farmer in the process of his appeal. And as such, any procedural failings that may well have happened in the course of the initial disciplinary hearing would have been remedied had he raised it, but because he didn't raise it, it raises the question as to whether he believed there was any procedural failing there.
Would you say that had the claimant been given notice of the particulars of the allegations against him, it would have made any difference to his refusal to delete the tweet? In other words, do you think if he'd had more time to consider the consequences of refusing to delete the tweet, it would have made any difference?
Madam, in my submission, it's highly unlikely. The refusal, as we've seen in the transcript, was quite round.
All right, carry on.
Thank you, Madam. Madam, moving on to the direct discrimination question. It's submitted that the claimant was not directly discriminated against. I've already made my submissions in relation to the reasons for the dismissal, and effectively it's repeated here that no discriminatory factor was relevant to the claimant's dismissal. It was entirely due to his gross misconduct, and there is no prima facie case that the reason for the claimant's dismissal was in fact his sex. Now, the man flu comments were simply not properly classified as less favourable treatment, as was put to the claimant. These were comments which were made in good faith in the context of a jokey, light-hearted work environment, in which the claimant would also actively participate and, as he accepted, never objected to. This was therefore not properly characterised as less favourable treatment for this reason, and the claim must necessarily fail on this limb. And, Madam, in any event, the treatment was no less favourable than the treatment a hypothetical comparator would have experienced, as such jokes were made all the time between employees at the respondent's workplace. The mansplaining comments, now, this again is not less favourable treatment. It's submitted that this is a term that adequately and appropriately described the claimant's behaviour as he became patronising and condescending to Ms. Wilson during the disciplinary hearing. Indeed, if a woman had engaged in such behaviour and there were an equivalent term to describe such behaviour, Ms. Wilson would have used it. The claimant's manner of describing climate change, which preceded the comment, could well have been perceived as talking down to Ms. Wilson. And so, Madam, for this reason, it's submitted that to accurately label the claimant's behaviour with this particular phenomenon cannot constitute less favourable treatment. And, Madam, it is further denied that Ms. Wilson ever told the claimant to man up. The claimant may well have misheard Ms. Wilson in the disciplinary hearing, but the matter is inconclusive in the minute in any event. Now, moving on to harassment, Madam. My submissions here will be brief, as they largely relate to the submissions that I've already made in relation to direct discrimination. The dismissal, although it's conceded that a dismissal in a vacuum is unwanted conduct, for the reasons already submitted, this was not related to the claimant's protected characteristics. The dismissal was wholly and exclusively a matter of gross misconduct related to the claimant's tweets, and as such, bears no relation to the claimant's sex at all.
All right, I don't think I need to hear any more on harassment. I understand your points in relation to how you put them in your earlier part of your submissions, but I do have one question. If I find that the dismissal is gender related and therefore sex discrimination in breach of section 13 of the Equality Act, do you accept it is also a breach of section 26(1), an act of harassment based on gender?
Madam, in the hypothetical you were to find as such, I think it would be inevitable, yes.
All right, thank you for that. Anything more?
Madam, just very briefly, that on the jurisdiction point, that you find that there is a jurisdiction issue in relation specifically to the man flu comments in the winter of 2019. It's the respondent's submission that it would not be just and equitable for the tribunal to extend the time limits for acts that it submits were discrete and for which the claimant failed to bring any claim in any event. Madam, that concludes my submissions, unless I can be of any further assistance to you.
That's okay, thank you. That's good. Mr. Crozier?
Thank you, Madam. I'm going to run through the unfair dismissal claim and then turn to the various discrete allegations of harassment, discrimination, and how they fit together. But before I come on to any of that, there are three themes I want to pick out, and I would invite you to take into account when considering the individual and cumulative causes of action. The first theme I'd like to point you to is the selective adherence to the core values in social media policy. And I would contrast the treatment of Mr. Farmer with the long-standing conduct of Miss Earthy on Instagram, which appears to have been treated as completely unobjectionable, doesn't result in any action inevitably being taken against the CEO, certainly doesn't result in dismissal. The second key theme I would like to pick up on is the undercurrent that we see in this case of gender-based language and gendered abuse of my client. And I'll come on to the detail of that in a moment, but it is important to bear that in mind when thinking in particular about Miss Wilson's decision-making. And the third key theme I'd like to bring to your attention or remind you of is the haste and prejudgment involved in this case. The haste in particular in Miss Wilson's rush to dismiss, it being about an hour and a half between first learning of the conduct to having dismissed my client after 10 years service, and the prejudgment in particular in Miss Earthy's initial reaction to the appeal, which she approached, I'd invite you to find, with a closed mind. Having identified those three key themes, I want to say something, first of all, about procedural unfairness and then substantive unfairness. Madam, you've identified the points about procedural unfairness. I don't need to take you through them in any great detail. There was no proper investigation, no notice to my client, no opportunity for my client to reflect upon what he had done and his approach to it. And that, in my submission, makes a real difference. Because what Mr. Farmer says in his unchallenged evidence, and it's at paragraph 14 of his witness statement, is if he'd had time to consider taking the tweet down and properly understood the consequences of it, if this had been approached in a calm manner, he may well have taken that tweet down. In fact, he says he would have done. So it does make a difference in my submission to the outcome. I turn to the substance of the dismissal. And what we say is that the conduct in this case was not and was never going to be sufficient explanation or reason for dismissal. And we say something else is in play in this case, and that is the animosity of Miss Wilson to the bloke in the store, the last man standing. And there was an opportunity presented by the tweet to remove the last bloke in the store, and it was an opportunity that Miss Wilson seized. There are two reasons why we say conduct isn't a sufficient explanation for the dismissal. The first of which is that Miss Earthy's own lifestyle and social media would suggest that Ethical Earth Foods doesn't either hold or police its commitment to its core values uniformly in the way in which it did to Mr. Farmer. Something else I would suggest is in play. The second point of substantive unfairness I would point to is the issue about removing the tweet. Miss Earthy says that this was pivotal to Miss Wilson's decision. If that is the case, if it is right that if Mr. Farmer had been given a proper opportunity to remove the tweet and had accepted that opportunity, then he deserved to have that opportunity properly presented to him at the disciplinary hearing, to have the same reflected at the appeal hearing, and be given the opportunity to save his job, and he wasn't on either occasion. And what I would invite the tribunal to find is that instead of the tweet being the reason for the dismissal, it was, as I have said, because of his sex, and a female employee, hypothetical comparative, would not have been subjected to the same treatment. I want to pick up very briefly on the three freestanding allegations of harassment, discrimination. First of all, on the extension of time point, as Mr. Devereux says, it's only in respect of the man food comment. It's some 5 months out of time unless there's some continuing act, and I'd invite you to find that there is. But if there isn't, the respondents notably point to no prejudice in their ability to answer this allegation. Indeed, it is, in one sense at least, admitted. So I would invite you to extend time and to find that the man-free comment was made because it is admitted, and to find, whatever you conclude on its purpose, that the effect of that comment was to violate Mr. Farmer's dignity, and that it wouldn't have been said to a man. Likewise, on mansplaining, I'd invite you to find, first of all, that the comment wouldn't have been made to a woman, and no comparable comment would have been made to a woman, and that it did serve the purpose, or at least have the effect of creating and intimidating and hostile environment for the claimant. And I would invite you to reach the same conclusion on the man up comment, and I would invite you to infer from the gendered language otherwise used by Miss Wilson that it is more likely on the balance of probabilities that she said man up as opposed to go up. Madam, those in outline are the submissions for Mr. Farmer, unless there's anything further I can assist you with.
Thank you. I'm going to move straight on to judgment, and I'll keep it as brief as your submissions, I hope. Firstly, I do find that the claimant was unfairly dismissed. Although I accept the disciplinary procedure, which we see in the bundle, is not contractual, it lays down the basics of a fair procedure and is consistent with the ACAS code. There were significant, and I emphasize significant, breaches of the procedure in this particular case. No investigation to speak of. When the issue of inconsistency was raised in the disciplinary hearing, there was no investigation of that. There was no written notice of the disciplinary hearing, including no notice of the allegations of the particulars, no opportunity to take down the tweet in advance of the disciplinary hearing, no notice that dismissal may be a penalty meted out to the claimant in advance of that meeting. There was no chance to bring a companion or a trade union rep, no chance to prepare. Egregious, I would say. So procedurally, it is unfair. I've also considered substantive unfairness in accordance with the Birchall test. Was there a genuinely held belief as to guilt of the claimant? Was it held on reasonable grounds? For the reasons I give below in relation to the allegations of discrimination, I find that the belief as to the misconduct was genuinely held. There was genuine offence at the tweet, genuine concern held about the tweet, and that was based on reasonable grounds. But I find that the dismissal sat outside the range of reasonable responses. In particular, I'm concerned that the claimant was not treated as others would have been, i.e. not treated consistently. I also take the view that there is evidence to suggest, and the claimant wasn't really challenged about this, that he had made complaints about climate change, complaints about people who held beliefs about climate change orally within the workspace in the years preceding his dismissal, and no one appears to have objected to it. So I do find that as it sits outside the range of reasonable responses, that the dismissal is also unfair substantively. On the Polkey issue, would the claimant have been dismissed in any event? I see no evidence to that effect. I take the view that he may well have taken the tweet down had he been given the opportunity to consider the consequences of a failure to do so. And I do make this point. I think anything other than a final written warning in these circumstances with an employee of 10 years standing to be outside the range of reasonable responses. Now, just pausing there, does it now take any view about the covert recording, given that that's come out of the wash? Is that something that might have led to the dismissal of the claimant?
Well, Madam, in relation to the covert recording, my only submission would be is that to covertly record fellow employees and potentially even supervisors within the workplace may well constitute a breach of any term of mutual trust and confidence between an employer and an employee, and to that end may well have been a material factor.
Well, given that it came out of the blue, what I'm going to allow you to do is to add it to a list of issues for the remedies hearing and pursue that Polkey point at the remedies hearing.
Thank you, Madam.
Just so I'm clear, the covert recording, would that have led to his dismissal in any event? I move on next to the issue of contributory fault in relation to the dismissal under section 1236 of the Employment Rights Act. I accept the conduct. The posting of the tweet was blameworthy. I accept that the refusal to remove the tweet, at least in the disciplinary hearing, the initial refusal, was also blameworthy. I do accept it contributed to the dismissal, and I do believe it is just and equal to make a reduction, but I only make it at 25% because of the points I've made earlier about the possibility that he would have removed it had he had more time to think about it. Wrongful dismissal, the next issue, I'm upholding this claim, which means the claimant is entitled to damages representing 9 weeks notice pay, which he was not paid and should have received. For the reasons I've already given, and I hope they're clear, I do not accept he committed gross misconduct, such as to entitle the respondent to dismiss without notice. In particular, in this regard, I note the right to free speech that's enshrined in the social media policy of the respondent at page 45. You can't have your cake and eat it, is what I would say to the respondent in that regard. Moving on to discrimination harassment, I'm grateful for the respondent's concession, if it is a concession, that if I find that the dismissal was section 13 discrimination on the grounds of gender, it is also harassment under section 26.1. But before I move on to that, I'll deal with the time point. I don't accept that this is conduct extending over a period. I regard the man flu remark made towards the end of 2019 as a standalone act, not involving the same manager or same individual. Should I extend time on the basis it's just and equitable to do so? I'm going to say no to that. And the reason I say no is this: it was recorded at the time, yet the claimant did nothing. He had ample evidence, and yet he did nothing with his complaint. He may have made a brief complaint to Miss Wilson at the time, but given the evidence he had in his hand, he should have lodged a grievance at that time. I should say, if I'm wrong about that, and of course without prejudice to that finding, I do find that the use of the words man flu, either on its own or repeatedly, is a detriment that is gender-based. And I have taken that into account in my later findings. Moving on to the other allegations of harassment, the man up and the mansplaining, I do not accept that mansplaining is gender harassment. It is simply a way of describing the unreasonable or inappropriate behavior of a man by a woman. It's calling out inappropriate behavior based on gender. So I don't accept that that is a detriment meted out on the grounds of gender under section 26.1. As for the man up remark, I don't accept that there is sufficient evidence for me to find that the remark was made during the disciplinary hearing. It isn't audible in relation to the recording, and I'm not persuaded that those words were used. Moving on to the dismissal itself, and of course this is the heart of the case, is the dismissal gender discrimination under section 13 and section 26.1. I find that it was. I'm struck by the inconsistency in treatment insofar as it relates to the dismissal, because it is clear that Miss Earthy has a lifestyle, and certainly did up until the time of the dismissal have a lifestyle that is inconsistent with the alleged policies of the organisation. Standing back for a moment, I see this case as one of the respondent taking an opportunity to remove somebody from the business that they had a difficult relationship with. Now, of course, unreasonable conduct, unfavourable treatment by itself is not enough. The fact that it was a hasty dismissal by itself may not be enough. But I'm struck by the something more that one needs in a discrimination case. And the something more is the manner in which Miss Wilson gave her evidence today and the comments she made during the course of her evidence. There is clear evidence to me that she has an issue around the blokey behaviour of the claimant. The use of her terminology suggests to me that the difficulties she accepts there were in the relationship are gender related. As such, I am finding that the dismissal was discriminatory on the grounds of the claimant's gender. That's a breach of section 13 and also a breach of section 26.1. Now, is there anything else we need to deal with today?
No, madam.
Not from our side, madam, no. We will pursue matters further at the remedies hearing.
Well, I hope the parties can resolve it without the need for a remedies hearing. I've given you my finding on contributory conduct. I appreciate we're left with a pulky point or a shagger point that relates to would he have been dismissed in any event, but I do hope you do not need to use any more of the tribunal's time. So thank you very much, everyone, for coming along today. We may have some questions from the observers for the purposes of this recording. Has anyone got any questions?
Hello, I have a question, if that's okay. Thank you very much for taking questions. My question is it normal that a judge would accept new evidence that's not included in a witness statement? And what's the criteria the judge would use to decide whether the new evidence is accepted or not? Thank you.
Should we just take turns with this one? Jesse, do you want to?
Yeah, I'm happy to. Is it usual? It used to be far more common than it is now, because it used to be the case that everyone would be in the same room and a diary entry could be photocopied and shared among everyone attending the hearing in about 10-15 minutes, and Hitesh and I could have stepped out of the room and listened to the recording together. It's far less common now with CVP hearings because the administrative side of it is very difficult to manage, and the only times I've had these issues crop up on CVP hearings have resulted in whole half days being taken out of a hearing so that documents can be shared and so on. The criteria are broadly relevance and prejudice. So in this case, the recording was plainly relevant. Hitesh said that it was prejudicial to him not to have heard it before. I think Suzanne was rather generous, personally. But yeah, relevance, prejudice, and then the judge's view. And that's where, in cases like this, it creates a great deal of risk for both sides.
I mean, ordinarily, if I can just add, you'd allow counsel probably to listen to the recording between themselves. If there's an issue about the fact that the recording started halfway through the conversation, there may be an issue about admissibility because of that. So, I mean, for the purposes of the recording, we did speed up the consideration of that point, but there would be more toing and froing in reality on that, I think.
Oh, thank you very much.
Any other questions from anyone?
Hi, I have a question.
Hi.
How open in general are social media accounts as evidence? So we saw two examples in this case of Twitter and Instagram. Is this something claimants should be aware of, cautious about, any way to protect against that?
Yeah, it's so as far as there's no general rule beyond the rules on admissibility and on disclosure. But I think as a general warning, I'd probably say that if it's a public social media account, it's probably fair to assume it's going to be fair game, because if someone can find it just by Googling you, it's very difficult to say that your public account wasn't something you were putting out into the public. I think points get complicated where you have a private account. Now, there's a fair deal of European Court of Human Rights case law on this, which is quite interesting. But when you have a private account, it becomes a bit more difficult, because in principle you have a right to privacy that may well be enshrined in the context of a personal private social media account. So, for example, here, if you've got a private social media account that's locked, or an Instagram account, that might not be fair game. That might not actually be something that could be admissible. And even within that, you've got further questions. You see very famous people on the internet who have millions of followers going private on their accounts. Now, how private is that really? And so then there's perhaps to and fro there. But for regular people like us who probably don't have millions of followers, I think one of the important factors is probably whether you're keeping your account private or public, or indeed the steps you take to maintain that distinction. But if someone can find what you've said through Google, it's probably fair to assume that that will probably be fair game for example, in cross-examination, as we saw today.
I think it would definitely be admissible if it was relevant.
Got it. And
to the privacy point, which is an Article 8 point.
And in this case in particular, would it have made a difference if Mr. Farmer hadn't put where he worked in his Twitter bio? I think you mentioned that.
If I can answer that, I think that it became relevant to the range of reasonable responses, because everyone could see where he worked, and therefore the impact on the reputation of the respondent was all the more clear by the fact that he tweeted. Had he been a person not known as he is, didn't mention the company name, then arguably there wouldn't have been reputational damage in the same way. Any other questions?
You mentioned the remedy hearing. Could you give us a little indication of the next steps that both parties would take?
Well,
to conclusion?
one would hope that they would settle it, given certain indications that have been given. But if not, either at the end of this hearing or by way of a further telephone case management hearing, then a listed hearing would be put in for however many days it can be agreed that would be needed for the remedies hearing. And you'd probably try and get an agreed list of issues about the remedy points. But, you know, in my experience, lawyers do their bit to narrow down the issues for remedy. So they'll agree the calculation of, you know, loss of pension, loss of bonus, future losses, etc. The big issue always seems to be how long would the future loss of earnings last for? And that tends to be what rolls you into a remedies hearing that could otherwise be avoided. Thank you. Anyone else? Any other questions?
I was wondering about the, oh, sorry.
You carry on.
I was wondering about the hypothetical act of taking down the tweet that was put forward by Mr. Crozier in his final submission, and you accepted that, Suzanne. And I just wondered how that decision would be taken when it is to do with the hypothetical act.
I think you just have to. I don't want to be vague and say you listen to the evidence and come to a conclusion and draw inferences. I think in relation to that, you look at how the claimant gave evidence and how strongly he holds his views and how unwilling he was to actually consider them to be wrong, offensive or unreasonable in any way. If he can't concede that at all, then why would he have taken down the tweet? The only basis upon which you might conclude that is that he was desperate to keep his job. So although you may conclude that he strongly believes in it and ordinarily would not take the tweet down, had he been told you're going to lose your job or you're very likely to if you don't, he might have taken it down. And those are the factors you'd take into account. I think there was another question. Hi.
Each witness was asked to confirm that they didn't have any extra notes with them. I just wanted to ask, what if you as the judge or as a barrister were in fact concerned that they had extra notes to assist them within their bundle or on a notepad? Would you be able to ask them to hold it up to the camera, or what would you do in that situation?
Yes, a good question. Perhaps both of you could answer that. Where you, because often with the video platform, you can't see the desk. And witnesses inevitably look down at what we believe is the clean bundle. But if you have concerns, how would you raise it and what would you expect the judge to do?
From my part, I've seen it raised both with good foundation and with bad foundation, where you can hear a phone pinging in the background or you're concerned that there are many, many different pieces of paper. There are limitations, but what I would do is I would ask the witness to confirm, possibly confirm again, that they're not looking at anything beyond a clean copy of the bundle. If I thought they were using their phone or some other device, I'd raise that suspicion with them. But all of this has its limitation in that if you have a devious witness determined to be coached and clever in being coached on a separate screen in front of them, it is very, very difficult to pin that down. You can ask what questions you like about it, and perhaps the judge might pick up on it and exercise their own concern about it.
Might a judge ask the witness to move their laptop or their webcam to show the desk and that there are no notes there, or is that a step too far in your view?
I think you would need a great deal of suspicion to get a judge to that point. But if you had that great deal of suspicion, and if the denials were not particularly persuasive, I can see a circumstance in which a judge would say that, yes.
Yeah, I think it's exactly right. It's the degree of suspicion that you have that really informs how aggressively you're going to go after it. So if you're looking at me, I'm looking this way, I'm looking that way. That's because I have two monitors there, right? So that's fine if your counsel are asking questions, you're looking at a bundle. But if a witness starts doing that, you wonder, well, why are they looking left and right? They could have that bundle there, they might not. And so I think I'd probably take it the same way as Jesse. I'd ask the question again as to are you looking at a clean copy? Are you looking at anything else? But I think the point at which it reaches the threshold where you have a serious concern, that's probably then when you have to start maybe even addressing the judge about it. And then I think it's in their hands to determine how they want to proceed. It could well be that they ask you to move a webcam or ask you to show your desk somehow. Most people, I tend to find witnesses tend to join on laptops or tablets, so it tends to be the case that it's actually quite a mobile situation, so they would actually be able to just turn their laptop or tablet or whatever to show their desk if it came to that. But I think, yeah, that to get to that point, you probably have to have something a bit more than someone looking left or right whilst they're giving their evidence.
And I think a judge would be pretty unimpressed with the barrister raising that point unless they had good grounds for doing so.
I think that's absolutely right, and we need to be careful. The other point, of course, is, does it really matter? Because if someone is, if a witness has their phone bleeping all the time and someone's clearly trying to get in touch with them, possibly about the case, possibly about something else, but you're making good headway in cross-examination where you know what they're going to say, because the evidence isn't particularly controversial, just plough on. So you do have to think carefully about whether it's really worth raising the point and whether actually you're getting what you need anyway.
I mean, the other thing about it being a video platform is whenever you take a break in a live tribunal situation, by which I mean in a building, then the judge will give a warning that the witness who is giving evidence at that time must not speak to anyone about their evidence or about the case. And you know, there are usually glass windows into the respondent's waiting room and the claimant's waiting room, and you can look in to see whether the witness is sitting on their own during the break or not, or chatting to somebody. But of course, if there is a break in the video session, you have no visibility on that. You cannot know. But witnesses, you know, they do sometimes come back from breaks and say something. I don't want to talk about one of my cases, but it was so obvious when the claimant came back into the witness box that they had legal advice, actually, in the break, the 1 hour break, as to how they should answer certain questions. So there are ways of detecting it, though it is more difficult with a video platform, without a doubt. Any other questions?
Yes. What happens if a witness doesn't turn up on the day, but there's a valid reason behind it, or if they kind of rush in at the end of the hearing, would their statement still be taken into account?
Yeah, I don't think we really got to that in submissions with Ms. Good. It depends on the reason, but the weight you attach to it is not great at all, because it's not subject to cross-examination. Therefore, it can't be tested. So not a lot of weight is attached if the witness does not turn up.
Oh, I see. Thank you.
Anyone else?
I just have one more quick question, if that's okay. Post-COVID, when everything's all back to normal, do you think that some tribunals will continue over remote video or not?
Jesse, Hitesh, what do you think?
I think everyone has been pleasantly surprised by how, I was going to say how well it works, perhaps not, I wouldn't go quite that far, but how we have been able to progress matters via CVP. I suspect a lot of case management type hearings and short point preliminary hearings or short final hearings might be done this way. It gives a new way of dealing with, for example, witnesses who have difficulty traveling, difficulty with mobility, and so on. So I think it's a very new tool in the tribunal's armory, and I think it will be used a fair amount. I also think that the lawyers and judges are very much looking forward to those heavy multi-day cases being heard in person again.
Yeah, basically, I entirely agree. It's I think a lot of people, I think, are quite pleased with how, especially smaller stuff, like a lot of the PHs I've done have been, sorry, that's a preliminary hearing, but a lot of the preliminary hearings I've done have largely been over CVP, And yeah, when you've not got heavy evidence issues, it does make you wonder why everyone needs to trek to the same place at the same time when you can just do it from home and the matter gets resolved in exactly the same way, maybe even quicker. But even then, I've had I did a small claims hearing yesterday where I was cross-examining someone on the basis of electricity bills, which it's complicated and very sort of granular. And I think those are the kinds of cases where perhaps you don't want to be doing it via CVP, because you're placing a lot of trust in any witnesses to actually have all the papers in front of them and to be able to navigate through a bundle properly, which if you're in a tribunal, it's there for them. It's you take that element out, but you reintroduce that becomes quite difficult. If I say, Mr. Blah, can you turn to page 17 in the bill on the 10th of July? And he says, I don't know where that is. Is that in this bundle? Is that in the, because we assume a lot as lawyers that people understand what bundles are, that people understand what a defense is, etc. They might not. If I say to you, can you go to defendant's bundle, and they're like, is that the defense with the annexes? Is that the second document set you sent me? So having it all in one place in a sort of more controlled environment, I think, is for larger cases definitely necessary.
Yeah. With multiple bundles, you can always see when the witness is looking in the wrong one when you're physically present.
Yeah.
That is often the case.
Yeah.
But it's certainly, I'd say, for people with parental and caring responsibilities, I think having remote hearings, at least the smaller ones, has been a godsend. So thank you to everyone for coming along, and I do hope that was informative. Many thanks.
Thank you.
Thank you very much.